2, 3, 4, 5, 6. Testing. 1, 2, 3, 4. Okay. One, two, three, 4, 5, 6, 7, 8. Okay. Testing. 1, 2, 3. 1, 2, 3, 4, 5. Testing. 1, 2, 3, 4, 5. Okay. Testing. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay. 1, 2, 3. Good. Okay.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on our docket today is Thach versus the State of Florida. Counsel? Certainly.
The court considered evidence presented at the trial when determining whether a mistrial admission is constitutional. We think not, that the determination of virtue shall be based upon the allegations within the information that was what the defendant must draw on, not the evidence presented at trial. Because the issue is, was the defendant given notice of the charge prior to trial, not whether the amended charge could be based upon the evidence presented at trial. As in the analysis that the trial court and the DCA was made, they considered the evidence at trial, not the information that the defendant must find out. Lewd molestation is not a of either charged offenses of capital sexual value or sexual value by one custodial position. Therefore, you had no news from those four counts that he would be convicted of that lesser included offense. the fact that there were other charges of lascivious molestation is irrelevant, as each count stands independently.
Counsel, I'm sorry to interrupt you. Can I ask you a question? Do you have is your entire argument based on per se prejudice, or do you have arguments that even if we accept the premise that we should do a prejudice analysis, that you could prevail on that?
Yes, so if you read this court's opinion in judicial, it says you get to present reversible error by using the harmless error test. And basically, Your Honor, the per se reversible error is just a standard that says every time you do the harmless error analysis for a type of error, you always get the harmful error. So, for instance, like in this case, where the defendant was convicted of a charge he did not go to trial on, which is a due process violation, that always got to be prejudicial. So, in my opinion, whether you realize the harmful analysis or not, or whether you say it's per se reversible error, you get the same result.
Okay, thank you.
The only other thing I would ask is that if you allow the DCA opinion to stand, whereby the state can amend as far as after presenting the evidence, or the wrong time to state is that they can wait to amend the information to fit the evidence at trial, and therefore nullifying the purpose of the information to begin with. If there are no other questions, I would like to reserve my remaining time for rebuttal.
Thank you. Counsel?
May it please the court, Virginia Harris on behalf of the state of Florida. I understood petitioner's argument to kind of go in two parts from her brief and some of her statements today. And I understood her argument to be that for the first part, that petitioner was prejudiced because he had claimed at trial that he could have potentially asked questions about the nature of the touching. And we don't agree. The record shows otherwise. The defendant's defense, even though he had already been charged with a count of lewd or lascivious molestation against each victim, he still came in and only argued that the victims had fabricated these allegations because they didn't like their stepfather, he was abusing their mom, he was a disciplinarian, and because of a specific fight that happened where the defendant was arrested. So that shows that he wasn't going to do that. In addition, the type of allegations we have here are not ones where you could make a credible argument that there wasn't lewd or lascivious touching. For the most part, all of the incidents occurred with the defendant going into the children's room at night, getting in their beds, putting his penis up against their butt, their anus, putting his hand on the vagina. There's discussion of his penis and their mouth, actually having sex with one of them, penetration, and there's many instances. Even though all three of the children were jointly tried, they were also similar fact victims, and the state also introduced other similar fact instances that weren't charged for some of the children. So it's very clear from these circumstances that if he did it, there was lewd or lascivious intent. There's no argument. This isn't a tickling incident from the living room where he says, wow, I was tickling her and she turned the wrong way and I accidentally touched something I shouldn't have.
I'm just curious as to how far along the trial do you take the position that the state, under these circumstances, would have been permitted to amend the information?
Well,
Here was after directed verdict, correct?
well, it was at the part where they were talking about the judgment of acquittal.
Right.
And quite frankly, usually when the state does substantively amend a case, it's because there's been a factual development at trial, and they are worried about surviving.
So it actually, the defendant could have testified, present evidence, rest,
Right,
and then
he-
the prosecutor could step up and approach the bench judge. Now I'd like to amend the information to add this other element,
Well,
or change this element.
I haven't seen case law that.
Well, I'm asking how you think. How far do you think we can go, or you can go, in changing the elements of a crime?
Well, I guess based on the language in the case law that it's as long as he's not prejudiced. But obviously, if
Well,
you
what
went-
about it? Let's say the jury comes back with a verdict, not guilty. Can you change the
No.
the elements at that time? Well,
Well,
why
it's-
not?
Well, it's
I mean,
over at that point.
Well, a directed verdict, if it's granted, is over.
No, I don't think the state. I think the trial would still have to be ongoing for the state to be able to. If it was actually submitted to the jury and they rendered a verdict, then
All
that
right,
would
so,
be.
okay, so let's say the end of closing arguments. Then the prosecutor steps forward to the bench, says, Judge, I'd like to change the information and the elements, and I'd like to change the jury instruction.
I don't think that the state could show that there wasn't prejudice under those circumstances, because you've changed the charges and he or she didn't get to make any argument on that. So I don't see how the defendant couldn't be prejudiced there. We're not suggesting that the state should be able to go around amending informations to change the charge at will. In fact, in many circumstances, the defense would be prejudiced. We're just saying under these circumstances, he wasn't prejudiced. And I don't actually disagree a whole lot with the other cases that were decided or mentioned by petitioner. I think this case is a unique set of circumstances. How often do you have a defendant already charged with 3 counts against each victim of the charge that's amended to, the lewd or lascivious molestation? How often do you have a case where you really just can't challenge the lewd or lascivious touching? You know that he wasn't going to challenge that. And then also in this case, you learn from his closing argument that it actually would have hurt his defense, because in his closing, he argues that the victims aren't credible. And one of the reasons he argues that is because they weren't detailed enough. So obviously he wouldn't have wanted to ask more questions to get them to give more details, because that would have derailed his defense. And I also would like to point out what took place when this conversation arose. There was a discussion about whether or not the state could amend these charges. The judge said, I'm going to give the parties 2 hours to think about this. If you finish sooner, contact my JA. They come back after 30 minutes, just a little bit more than 30 minutes. The state says, I want to amend these to molestation. The defense is not prejudice. The judge asks for a response. The defense attorney says, I'm going to object on the timeliness alone and leave it at that. He wasn't even going to argue he wasn't prejudiced. The judge then prods a little bit more, and he says, can you articulate any prejudice? And he says, well, I guess the only thing is there is this lewd or lascivious intent, and potentially I could have asked more questions about this touching. So he was really making a token objection here. And the standard is that you have to show the defendant's substantial rights were prejudiced. Well, was he really saying that? I looked up the word substantial, and it talks about great worth, importance, actually existing. If you say that a defendant is you're only potentially could have asked questions, is that actually existing prejudice? Because he's only saying that it's potential.
But isn't substantial, isn't that sort of a legal term of art for due process?
Yeah, I looked it up, and because your case law, Lacos and State versus Anderson, was done more in the 80s, I looked it up from the same Black's Law dictionary that I looked up the word substantive, which means essential or integral. And that is where I got the definition from. And so it's Black's Law dictionary. And I can supplement with that if you'd like.
Counsel, leaving aside a judgment of conviction, what about petitioner's argument that a lack of notice can in and of itself constitute prejudice?
I don't really agree that he was. I consider notice, and I think most trial parties do, as a practical matter. And in this case, the 4 counts that we're talking about, he was charged with sexual battery and 2 of the counts, and sexual activity in the other 2. And the acts were penetration or union with the vagina, penetration or union with the finger, that is, penetration or union with the anus with his penis, and then the other one is touching the anus or penetration, and then the other one is digital penetration of the vagina. So he was on notice of the sexual nature of the offenses. This court has even indicated in Ruffton that as a practical matter, the acts constituting capital sexual battery would include a lewd or lascivious molestation. Under these circumstances, you can't really have one without the other. It's like the First District stated, to prove the greater offense, the lesser of the, well, not the lesser included, but the molestation had to occur first. For example, technically in the counts that allege digital penetration or union, union by the finger is not a capital sexual battery. So that allegation couldn't have been, even as it stood in there. There had to be penetration by the finger. So you would already know if that testimony came out that that would have to be changed. And in order to, based on these circumstances with these young children sleeping in the bed on their side, when he comes in to do these things, you cannot you can't penetrate the vagina without touching it first. You can't touch the anus with your penis or penetrate it without touching the buttocks first. These things had to happen in order for the greater offenses to occur. And that's one of the reasons that the First District distinguished this case from the other cases where the crimes were just changed. Something like fingers being changed to oral sex, where they're just completely changing the charge. In this case, it would just showed a lesser degree of touching. So in this case, we do believe that he was, and think about it for a second, just from a common sense perspective, and I know Justice Labarga was a defense attorney at one point. Imagine a defense attorney getting up in front of these jurors and saying, okay, the defendant did not do this. These stepdaughters made this up, but even if you believe that these acts occurred, they didn't demonstrate that he had a lewd or lascivious intent. I mean, you can't credibly make that argument under these circumstances. It's just not credible.
So isn't that somewhat his point? That if you have, that's your theory of the case, and that's what you're going with, but all of a sudden you have different charges, maybe you would have done something differently as a theory of the case.
But the only thing that he actually didn't even really say he would, he just said potentially. But the record shows that he wouldn't have, because each victim, he didn't go through each count and say, well, what about here and what about here and what about...
But we really don't know, do we? Because it was changed. We don't really know exactly what he would have done.
Well, since it was done at the JOA stage, we do know, because he already gave his opening statements, and he's totally arguing that these girls fabricated what happened. We can see how he cross-examined the victims, and he never asked them any questions about the nature of the touching. And in reality, you wouldn't want to do that as a defense attorney. I mean, think about it. These victims, what happens with these sorts of cases is a lot of times the children have been abused for a long period of time, and there's a delay of reporting, and that's what happened in this case. Then there's the CTP interviews, and then 2 years later we have a trial. So these little girls are being asked to remember things that happened years ago. And they may not remember on any particular occasion whether he actually penetrated or just touched their butt. And so why would we want to let, under these circumstances, because the error and prejudice analysis are intertwined, if there's prejudice, it's reversible error. We're talking about letting somebody go simply because a little child couldn't remember many years later whether or not he actually penetrated or not, when his defense he wasn't prejudiced at all by this.
But in terms of the legal rule, I mean, what you're asking us to say is that the burden would be on the defense, instead of us kind of speculating as to could this or that have been different. They at least have to articulate prejudice, and then the court can evaluate.
Right. And I really wish you, and I have that in my statement of the case and facts, but you would look at that. He wasn't even going to argue that. And it's because it's not credible. And that's probably why he argued that so meekly, because everybody that's down there with these type of allegations, you can't credibly argue that if they were done. I mean, what other questions are you going to ask? And the state asked quite a bit of questions about the nature of the touching. What other questions would he ask if about the touching under these circumstances to suggest that they weren't lewd or lascivious? He wasn't prejudiced at all. He was just making a token objection because, no defense attorney wants to be the bad person that didn't preserve the issue on appeal, and he doesn't want to get an ineffective assistance of counsel later. But the record clearly shows that he wasn't prejudiced. And then I'd also, if there aren't any more questions about that.
Isn't this essentially the same prejudice analysis that trial judges do day in and day out under Richardson? Procedural prejudice?
It's very akin to a Richardson hearing, because what happens, the state hopefully inadvertently gives the defense some new evidence in the middle of the trial, and then he has to say how he's procedurally prejudiced. In this case, after being told that he could have 2 hours to think this over, that's all he could say. Potentially, he could have asked these questions. And one more thing I want to mention is that when kids come out and they forget certain things about the testimony, the last thing that you want that favor you, the last thing you want to do as a defense attorney is go up there and start asking them more questions about the touching. You run the risk of having them remember or change their mind about what they said. That's not a good idea. And that's not what he was going to do. And I think you can look at this record and look at the way he presented his argument and see that that's not the case. It's not just that he wasn't greatly prejudiced. He wasn't prejudiced at all in this case. And then going to the second part where she says a per se rule should be applied. Well, I don't think a per se rule should be applied. In fact, I think per se rules should be limited to structural error. I mean, we have it's 924-33 where our legislature doesn't want us automatically reverse things. They want the defendant's substantial rights to be prejudiced. The language from this court's precedent for amending an information mirrors that. And I think that the language in DiGilio is very sound. When you're thinking about imposing a per se rule, then you should only do it in circumstances where it would always be harmful. And you have nothing to lose by not imposing a per se rule. If something is always harmful and it goes through a prejudice analysis, it'll get reversed. So nothing bad will happen. Whereas if you make this per se prejudicial, there will be a unspecified number of cases where the defendants are not prejudiced at all. And that would be an injustice. And we have, jury trials where judges and parties get ready for the trial. People have to get off of work to go in. It costs taxpayers lots of money. The victims, especially in cases like this, have to go through this ordeal. And so why are we reversing after a jury's found him guilty if he's not prejudiced at all? And like I said, in the normal circumstances, you determine if there's error and then if there's prejudice, and there would be a new trial. But in this case, there's no new trial. The defendant would, in this case, he wouldn't walk because there are other counts and there is a lesser included of battery. But in some cases, it could result in a defendant actually walking away. Petitioner is actually asking this court to engage in policy making that's inconsistent with that of the legislature. And I mentioned that I was hoping this court would limit per se to structural error. And I think that would make it easier for you because the United States Supreme Court has very clear precedent on that. You don't have to follow them, but if you did, you wouldn't have to worry about running afoul to their case law.
Justice LaBarger raised a point about, is there a point in time that you've gone too far to be able to change the charges? Is there a point in time where, okay, this has gone way too far. We've submitted this to the jury, and the charges should not be changed. What point in time is there any point in time that's too late?
After it's gone to the jury, in my opinion, that would definitely be too late because you've already made your arguments. How could a defendant not be prejudiced?
One would think. How about the jury instructions?
Well, it depends. Sometimes the judges give the jury instructions before closing arguments, sometimes after. I would think it would have to still be while the evidentiary portion was going on.
So I'm clear. Your point here is that after closing arguments, no more amending the information.
No more amending information.
So, and by the way, I was a prosecutor a lot longer than I was a defense lawyer. So let me sneak that one in. So that's your point. So once the lawyers get out there and argue, closing arguments, that's it.
Yeah, because how could a defense attorney not be prejudiced there if he's making his argument to a jury and all of a sudden the charges are changed? I don't see how you could possibly not be prejudiced.
But you're not asking.
Hang on for a second. How about opening statements when lawyers get up and tell the jury, this is what I believe or what we believe the evidence is going to show? You're kind of, if you're any trial lawyer that attended all these courses you take to know how to try cases, they tell you that a lot of juries make up their minds after opening statements. And the thing is, you are basically making a promise, in a sense, without saying the word, to the jury. The evidence is going to show this, 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 and that. And then the defense lawyer gets up, the evidence is not going to show this, 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 and that. It's going to show this. Aren't lawyers at that point in time committed to what the charges are? By that point in time, you change the rules or
Well, no, Your Honor. First of all, juries receive instructions that informations are not evidence and aren't supposed to be considered as such. And the same thing about opening statement. But even in
the same thing can be said about closing argument.
But in regular trials, you have multiple counts, and certain counts are JO8 or reduced to a battery, and they go to a jury. And we're still allowed to do that. So why would that be any different?
Well, would closing arguments be any different? You said that you can't change the document after closing arguments. Lawyer makes closing argument. Why would that be different?
In this case, I believe he gave them the instructions.
Well, I'm talking about in general, because we're going to make a ruling here, one way or the other. In general, after closing arguments, how is that different than opening statement?
Because the evidentiary portion hasn't started yet. The defense can still question his witnesses and decide what he's going to argue and what not, at that point, the trial's over. The evidentiary portion is over at that point.
But you're being led down this path. But I mean, the bottom line is, what we have to decide is, are you going to do a prejudice analysis, or are you going to do it per se? The point isn't to sort of speculate about other things where you might want to narrow or per se. The point is, all these kind of parade of horribles type things, it probably wouldn't be hard to show prejudice. You don't need to sort of lock yourself into these other types of things. I mean, it's either a prejudice analysis or there isn't prejudice analysis.
Right, and in my view, your case law already says that. I mean, in the Clements case, the state actually added a whole nother charge. That's not just a change of an essential element, that's a whole bunch of new essential elements. And this court indicated that the trial court properly conducted a prejudice analysis and did not allow the state to amend the information. This court did not say it was per se error. But by adopting the structural error, limiting per se to structural error, you're getting the judiciary out of the policy-making business.
In this case, were the amendments before or after jury instructions?
They were before. But I don't think, like I said, it's not as though I'm arguing that the state should just have unfettered discretion to amend an information. There are many circumstances where the defense would be prejudiced. I mean, think about it. The defense attorney can argue that he is prejudiced in his investigation or in the nature of his defense. It's actually not that hard to argue your prejudice. It was just particularly hard under these unique circumstances. I don't think this happens a lot. I'm not sure.
Counsel, you're well over your time here.
Okay.
If you could sum up in about 30 seconds.
Okay. Well, if there aren't any more questions, we ask that you approve the decision of the First District and that you not impose a per se rule in this case. Thank you.
Thank you. Rebuttal.
So, as you heard, the respondent refers to the evidence at trial and refers to what the defense may have argued. That's not the right analysis. The analysis should be based on the allegations only within the 4 charges that were omitted. And you get a lot of prejudice. And the fact that you could not go back and ask about a matter of attention. I will also remind you that you're holding Russian specifically says that lewd and lascivious molestation is a separate and distinct offense from capital sexual violence. So, it is a whole new charge because lewd lascivious element is the matter of touching. There are physical points that you need to pick up on is that the state initially agreed that it did not prove penetration on this 4 counts. When the defendant made the declaration, only after the 2 hours did the state come back and say, well, why would you amend the information to allege lewd and lascivious molestation? I plead with you to go ahead and use harmless error and and respondent suggested. You come up with the same results. One client got convicted of the charge. He did not go to trial. Now, the state has the power to amend the information as much as they want for this trial. But they have the witnesses. They have a power. The only time the power is limited is a trial. Therefore, we would argue to allow them to amend after the evidence would be to give them unfettered discretion to amend and to allow them to wait until they can amend to fit the evidence that came out at the trial. I urge you to reverse the 4 convictions and find my client was indeed prejudiced by the mid-trial amendments. Thank you.
Thank you. We thank you both for your arguments in this case today. And the court will now proceed to our next case, the case of Ritchie versus the state of Florida.
Good morning.
Morning.
Mr. Chief Justice, and may it please the court. The penalty phase closing argument in this case should make conscientious prosecutors cringe. Prosecutor Harmon attacked Ritchie for exercising his constitutional rights and then intimated that because he was a non-citizen, he did not deserve them. He violated the same mercy rule, he violated the golden rule, and eventually vitiated the jury's ability to extend mercy. Prosecutor Harmon's hunger for a win inflamed both the passions and the prejudices of this jury and infected Ritchie's entire penalty phase trial with constitutional error. Today, I'm going to focus on some of the most egregious instances of that closing argument and the mother's victim impact testimony where she made a direct plea to the jury that they impose a death verdict.
Is your argument cumulative? Is the argument that the statements in their entirety
Absolutely.
merit reversal? Okay. I wonder if before we get to that, though,
Sure.
we might, first of all, have we ever reversed on the basis of the same mercy argument alone? Have we ever found that standing alone, a same mercy comment in closing or elsewhere in trial constitutes reversible error?
I do not believe so. However, it's not standing alone. That's not how the harm analysis
I agree.
works.
I just want to make sure that I
No.
understand the component parts. Okay.
Not that I know of.
Certainly a golden rule violation we have
Yes.
held can constitute reversible error.
Yes.
What about the immigration commentary?
Not that I know of. However, it may not be a common argument. That may be why we don't have an opinion on it.
Okay. And so for your theory to prevail, we shouldn't be looking to the same mercy alone. We shouldn't be looking to anything alone. Your argument is one of cumulative prejudice.
Absolutely. I want to say something about prejudice, and it applies whether or not you're doing harmless scrutiny or whether or not you're doing fundamental scrutiny. The impact of prejudice looms so much larger in a penalty phase than it does in any other proceeding in America. And the reason for that is not just because each individual of those 12 jurors has veto power over a death verdict, but because unlike guilt phase determinations, conviction determinations that turn largely on the evaluation of objective facts, whether or not to kill someone is an inherently moral determination. And each individual of those 12 jurors brings with them to death and life deliberations unknowable ranges of human experience, unknowable ranges of reactions to the same types of evidence, and it's because of that that their collective judgment about who should live and who should die is marked by an inherent lack of predictability. I want to talk about, I think, the most egregious.
Well, where does that leave you? Does that leave you basically saying any error in the penalty phase is a per se error?
No, absolutely not. I can think of.
Well, what does it mean then? I mean, because it sounds like you're trying to change the standard, the typical standard we would use for determining harmless error, right? You're saying that's got to be different.
No, I'm saying that what the jury does is different. So this idea, for instance, when you have a trial, is there enough evidence to convict is not the only question you ask yourself when you're going through harmless error analysis. But it is a big part of it. Is there sufficient evidence to convict but for the harmless or the prejudicial arguments? For example, I think something in a penalty phase closing in a capital trial that the prosecutor says it's improper about an aggravator that the jury ultimately doesn't find, that they reject. I think that would be harmless. I think that would be very hard for me to come here and argue prejudice if that happened. But that's not what we have here.
Well, what you do have, though, is the presence, for example, of an HAC aggravator.
Sorry?
What you do have, for example, is the presence of an HAC aggravator.
Absolutely.
All right. So, I mean, I guess to the Chief's question, I mean, it can't be per se error for there to be a comment that we, for example, have never found to constitute standing alone error when there is an aggravator in the record found beyond a reasonable doubt. You'd agree that again, that you're not asking us to hang everything on that. You are making solely a cumulative error argument.
Absolutely. But I do want to distinguish, I mean, some arguments were certainly worse than others. The worst, I think, of the entire penalty phase was obviously the comment on trial rights intertwined with this, he wouldn't have had access to any of these rights in Jamaica refrain. The whole point of patriotism, frankly, is that you owe more to your brethren than you owe to outsiders. Remarks on the comment on the exercise of trial rights would be egregious in any case, right? Because the state's burden to mount its case presupposes a counterburden on the jury to sit through it. But it's especially egregious to tell the jury, we gave this man, because our country is so great, we gave him all of these rights, and he wouldn't have even had them had he been tried.
But is that what's actually in the record? As I recall the record, it was the defense that put before the jury the idea that he had grown up under underprivileged circumstances in Jamaica, and the state responded on this basis. Can you give us the actual statements in the record? Because I don't recall it being what you're saying.
I'll read it. He immigrated here to this country years ago, and as he lived here, he enjoyed the benefits of this country we live in, the greatest country on the face of the earth. He enjoyed the due process rights. He enjoyed the fact that we carry the burden of proof to prove his guilt, that he's presumed innocent, that he's entitled to a jury of his peers, not just to determine whether he's guilty, but a jury of his peers to determine the appropriate sentence. Because this isn't Jamaica or some other country, this is the United States, where the defendant gets to have you determine his sentence, not some bureaucrat, not some single judge, not a star chamber, but you, his fellow citizens. He enjoyed the benefit of a neutral and unbiased judge, the benefit of very competent defense counsel. You think that would have happened in Jamaica? I don't see how that's responsive at all to a claim of underprivilege or, a terrible childhood. For instance, or any of his mental mitigation. For instance, if there was some evidence that Ritchie had gone through like a long and arduous and labyrinthine immigration process, the prosecutor could have easily said, what fool could have figured that out? I mean, obviously he's got some tenacity, right? But that's not what happened. And also he could have easily said, his father sounds like a terrible guy, but, he's not that little boy anymore. He's a grown man who did a terrible thing. But also that's not what he said. He went through a litany of trial rights, which this court in Evans says there's no legitimate purpose for doing. And then he intertwined that refrain with a reminder to the jury that he's not from here. And the only logical, conclusion that a jury can take from that is that I should be dubious.
Let me ask you this
Yes.
quick question. When did this trial take place? What was the date?
September 2019, the last...
What year?
2019.
2019?
The crime is in 14. I want to go...
The way that you're arguing this and the way you presented it is a little confusing to me. It may just be me, but on the same mercy comments, we have case law that says that those are blatantly impermissible. Is that correct?
Correct.
And there was an objection at trial, correct?
Yes.
Okay. So it's preserved error. Clearly
Yes.
error. We said it's error. It's preserved error. So that means the state has to show beyond a reasonable doubt that the error did not contribute to the outcome.
Yes.
You seem to be conceding that the state's met its burden because you're not arguing that we should reverse based on that alone. You're saying that we should somehow accumulate with other errors that were not preserved and therefore have this different standard that's very difficult for you to meet. So
Our position absolutely is that the state has a burden of proof to prove to you beyond a reasonable doubt that the same mercy comment did not impact the verdict. But this closing argument was so terrible that the same mercy argument was compounded by other error.
If the state didn't demonstrate beyond a reasonable doubt that that error alone did not contribute to the verdict, then it doesn't matter if we've ever reversed based on that before, right? It's a reversal.
That's true.
Okay. So why isn't the argument trying to convince us that the state has not shown beyond a reasonable doubt that that error did not, yeah.
Well, I believe
Yeah.
I believe it's impossible for them to prove that to you because there's no way to look to a penalty phase deliberation as if it's a lab experiment that you could sort of replicate and that you would reliably get the same exact result, a 12-0, a 12-0, a 12-0, no matter how many times you did it. I think thinking of penalty phase deliberations like that is woefully misguided. And I think that's the only way the state wins, if you think of penalty phase argument like that.
Let me ask you, going to golden ruling in HAC, the classical golden ruling argument would be something to the effect of, put yourself in the shoes of the victim.
Right.
Think of how she felt as she was dying and so on and on. That would be the classic golden ruling argument, impermissible golden.
That did happen here.
Well, I'm getting there.
Okay.
Hang on. Here, the argument was can you imagine the dread of knowing that your life is ending and you're feeling pain all over your body, as it's bleeding internally and so on and on? Okay, how, that is not exactly putting yourself in the shoes of the victim, but pretty close to it. How is it that this argument is being combined, obviously, with HAC, heinous, atrocious, and cruel, that aggravator? How is it that that would not be permissible just to prove HAC? It wasn't introduced on its own just to prove HAC.
It's absolutely permissible for a prosecutor, while they're referencing HAC, to say, to describe the pain, to describe the victim's pain, the ripping and tearing of tissue like he did in this case. That would be very painful. Dr. Downs told you how painful, how highly innervated those areas are. But the difference is asking the jury to imagine that the murder, that the death is personal to them.
So the proper way to have said that, or the better way to have said that as a prosecutor, would have been something to the effect of, you may consider
Yes,
how the victim felt at the time, something like that,
absolutely.
instead of just imagine.
Imagine you.
You, yeah.
Even imagine, I think, would be fine. But imagine you is not fine.
That's interesting. Why? If the argument were, imagine the suffering of this person, imagine the pain, isn't that directly inviting a personal experience? I mean, to imagine something is to call it to mind and to reflect on what it might be in my own experience. Why aren't you arguing that, isn't your rule essentially that any kind of personal contact with the experience should be a violation of the golden rule?
I don't think you can divorce these kinds of proceedings from personal imaginings or personal contact, but for instance, in a Thach case, the murder was pitiless. It is much harder for me to imagine giving mercy to a merciless killer when I imagine them murdering me versus when I imagine them murdering someone else, even if that victim is, sympathetic for some reason. I think there's a huge difference there. I want to touch on victim impact before I reserve some time for rebuttal. The victim's mother in this case read from the Bible to the jury, "If anyone causes one of these little ones, those who believe in me, to stumble, it would be better for them to have a millstone hung around their neck and be thrown into the sea." This demand directly to the jury for the death penalty suggests that God is on the side of a death verdict, and that is a perversion of Florida law. It also touches on the least controversial aspect of the Payne decision, and I'm referring, of course, to Payne's condemnation of survivor opinion on the defendant, the crime, or the appropriate punishment. We cite a lot of cases in the brief about victim impact, and I think victim impact, unless you are combining it in your consideration of the same mercy argument, which you can, cases like Del Hall and Evans say that you can do that, and you're under harmless error analysis, there was no objection here. So I think I need to address what it takes for victim impact to rise to the level of fundamental error. And my reading of the Florida case law, I believe, makes two requirements. One, it has to violate that Payne condemnation. It has to be a direct request to the jury to impose a death sentence. And cases like Jordan and Calise say that. They say that you don't reach the foundation of a penalty phase until you do that. Secondly, you can do that. You can make that error, even if it's plain and obvious, and there's no question. But unless you do it in front of the jury, it doesn't warrant a new penalty phase. And I get that from cases like Card. Are there any questions on victim impact?
Sorry, could you elaborate on this harmless error issue? Because
Sure.
I just want to make sure that we're clear as far as what you're arguing analytically that we're supposed to be asking ourselves. So, I mean, one way of looking at it is whether, you know, you have this sort of objective jury that is, you know, this, you're asking whether objectively speaking, in the context of this case, whether this same mercy comment that a rational jury could have decided differently because of that comment, right? I mean, is that what we're asking ourselves? Because,
Yes.
I mean, obviously, and I understand why you haven't emphasized this, but I mean, this is one of those cases where it's hard to imagine a different recommendation from a jury than what happened in this case. And so it seems hard to believe that, and I understand you're making your cumulative point, but you also were saying that, you know, because it was objected to that we need to do harmless error on the same mercy thing, but it seems it's hard to imagine that comment in isolation materially affecting what the ultimate recommendation was.
So I'll say three things. First of all, the danger with a same mercy argument is that not only will the jury permissibly use arguments about how the murder was pitiless when they're finding Thach sufficient or not, but they will also use it when they go to that ultimate last question. Will I extend unconditional mercy? They'll use it then too. That is what's impermissible about it, and that's what's so dangerous about it. And even though you can reverse, and we argue in the briefs and here today that you should, based on that alone, you don't have to do it on that alone, because you have so many more improprieties in penalty phase closing. And again, this is not guilt phase, this is penalty phase. The issue is whether he lives or dies, that compound that error and weigh it down. So you can, but you don't have to, I guess is my point here today. If you find yourself having trouble imagining, just based on that one comment, how someone would have voted life, think about the entire improprieties as a whole. And the third thing I'll say is your comment about it being hard to imagine. Frankly, some capital defendants get 11 ones and 10 twos, and you're right. It is like unfathomable how it happened. But it happens. And when you are at the point where you are in your mind saying, if we do this over, are they going to vote death again? It is highly, highly speculative for you to say for sure, because those, and they're not really anomalies, it's quite common actually, that you're not sure that that would happen. It's just very speculative to say that. Too speculative for a harmless error analysis. I'd like to, if I could, reserve the rest of my time. May I?
You may.
Thank you.
Thank you, Mr. Chief Justice, and may it please the court. My name is Rick Buckwalter, and I represent the appellee in this case, the state of Florida. Today, Granville Ritchie comes before this court and asks this court to reverse a death sentence imposed and remand his case for a new penalty phase because he contends, one, there was improper comments made by the assistant state attorney during his penalty phase closing. There were improper victim impact testimony that was admitted into evidence. The redactions that were made to a video they claim were improper, that was introduced for mitigation, and four, that the court permitted rebuttal from a witness that Mr. Ritchie argued, I guess, was incompetent to testify about the matter to testify about. However, because the jury's recommendation that Ritchie be sentenced to death was based on highly aggravated facts, that Ritchie raped and strangled to death a 9-year-old child, the recommendation any reasonable jury would have made, and that there's relatively limited mitigation evidence in this case, there is no reversible error. And therefore, we're going to request that this court affirm the sentence of death imposed by the trial court. There were several matters brought up this morning by defense counsel. and my intention is to limit my response to those remarks unless the court has further questions of me. With regard to the same mercy argument, the court should be aware that in Rhodes v. State, which is one of the cases cited by by counsel in this case, this court found that a same mercy argument alone was harmless error. We've contested whether or not it's the same mercy argument, whether or not it was in fact preserved, but to get down to brass tacks.
Can we talk about preservation for 1 second? What would have properly preserved the same mercy objection? I see the colloquy as being pretty clear. There's an objection, there's a motion for mistrial, and the court essentially says, all right, thank you, don't relate it to any mercy, the jury may or may not show the defendant, okay. Is it the state's position that the court didn't rule on
That's
that
correct.
objection?
That is the state's position, but again, I think it's important, even though that's the state's position, and if it's not preserved, it's a different analysis this court would use in reviewing the remark. I think the bottom line is that even if it had been preserved, this court said that those arguments, it's a harmless error.
No, I follow. I just want to make sure I understand the state's
Yes.
position about what constitutes a ruling sufficient to preserve an objection. And it sounds like the state's position is you need an actual statement saying overruled, or is the state's position that nothing short of that will preserve the error?
I don't think that trial counsel can require the court to make a ruling. I do think that trial counsel can bring it to the court's attention that there hasn't been a ruling and request a ruling.
The judge, here's what the judge said, is, I don't recall him saying that, but obviously relate the term mercy, relate it to the context of HAC. Don't relate it to any mercy the jury may or may not show the defendant, okay? That's what the judge said. I mean, I guess she could have said overrule or sustain, but that's what she said. It's even more specific. How is that not a ruling?
Because there hasn't been a formal ruling. However, as I was pointing out,
You want to hear the words, denied, granted, that kind of thing?
I think the court has to make a ruling, yes, Your Honor.
So how does the defense lawyer, who is savvy about these things, get a judge to do that?
If the court won't make a ruling, the lawyer can point that out to the court and request a ruling. If the court doesn't make a ruling at that point, there's nothing counsel can do. And I would say at that point, they've preserved the record by bringing notice to the court and pointing out that there hasn't actually been a ruling. However, in this case, as I'm pointing out to the court, even if the court were to find that it's the same mercy argument and that it was preserved, because it's harmless error, it doesn't matter whether in a case it was preserved, because this court's previously found in Rhodes that it is harmless error.
Let's set aside this particular issue for a moment. I think the defense argument is we've got other errors that would be considered to be fundamental, right? Because they were unobjected to. So I'm trying to determine what is it that we can aggregate together for cumulative effect purposes. Can you look at those other fundamental type errors, and even though individually they may not be reversible error rising to the level of a fundamental error, can you aggregate those together in that class together? And let's just stop there for a moment. Can you do that?
The court has done that previously. I questioned.
We've got case law doing that.
I believe the court has done that. I do question whether that's reasonable or not, because for a number of reasons. All right, I don't, maybe numbers.
So, but just stop there for a moment. We do have case law saying, yes, that's appropriate as a matter of law to aggregate those.
I don't know that court has come out with a statement saying, as a matter of law, that's the proper way to go
But we've
about
done
doing
it.
We've done
My
it.
point
What I
is
said
we
is the
have
court
done it.
has done it.
All right, so if we can do that, then should we combine also then the prejudicial effect of one that is preserved, this particular mercy aspect, and consider that with in a cumulative error analysis, this one that is preserved and together with all the others that are not. Is that an appropriate aggregation?
The court has looked at both objected to and objected to comments and taken a look at them. However, I do question the rationale of doing that for...
What standard?
I'm sorry?
And then you use the fundamental error
The fundamental error
standard for
standard, that's correct.
the objected and non-objected.
For a couple of reasons. One is with preserved errors, there's a different standard than there is with unpreserved errors. And with preserved errors, the burden shifts from one side to the other as opposed to unpreserved errors. But what the court said is you take a look at the totality of the evidence introduced. And in this case, what we have is a case with highly, highly aggravated facts and really relatively little, if not a paucity, of mitigation. What we have is an individual who raped and strangled to death a 9-year-old child. And there was graphic testimony from the medical examiner about the strangulation and the results. We're talking about...
Well, counsel, is the argument here that you're making really that because this is such an aggravated bad case, which cries out, it's a terrible case, that the prosecutor can basically say anything? They can transgress all sorts of rules, whether it's objected to or not. They can make comments like this immigration comment, which what that has to do with anything that is relevant in this case. It's hard for me to imagine. I mean, I can't see it. Come up with statements like that, and that's really all okay because it's such a terrible case?
I don't think we can say that a prosecutor can say anything in a case. I mean, at some point, we're going to get to a point where, regardless of the aggravation, there could be the type of prejudice where we would say that a jury wouldn't have found for the death penalty, wouldn't have recommended a death penalty but for the statements. But that's not this case. I mean, the facts in this case are just so highly aggravated.
I mean, going back to the same mercy, and it is questionable to me whether it is preserved because there wasn't a ruling secured. But assuming that it's preserved error, I'm struggling to see how I can determine beyond a reasonable doubt that an argument that we said is strictly prohibited, it's one of the worst arguments that you can make, that the prosecutor can do that. There can be an objection. It can be wrongfully overruled, and then we just say, well, it's so bad that there's no way that it even contributed to the outcome. I mean, if you take mercy completely off the table with that argument in the jury's mind, how can I say that didn't contribute to the verdict? Beyond a reasonable doubt that didn't contribute. You can make pretty much even the worst argument possible and still.
Courts have to make those type of decisions all the time. This court has had to make that decision on previous cases a large number of times. And as I said, it did in Rhodes. It would require a reversal of Rhodes, as I read Rhodes, for this court to determine that it should, at this point, not be harmless error. But yeah, the court often, I should say, finds itself in a position where it has to do that subsequent to the statements that are made. In this case, which you have to take a look at the totality of the evidence that was introduced in the case.
But it seems like the stronger the state's case, the more prosecutors feel they can say. If I had a nickel each time we had this conversation, at least I had this conversation here on court with attorney generals about that situation, I'd be a rich guy right now. The immigration one, think about it. That's why I asked the question. this trial took place in 2019. The whole political climate regarding immigration at that point in time was very hot in this country. And to raise that issue that had nothing to do with anything in this case, obviously was for obvious reasons. And we can say, okay, the evidence is strong, even though he said that there's no way a jury would have found him not guilty. You can speculate about that. Well, like she said earlier, before unanimity in jury recommendations were required, we found we had jury trials as heinous, atrocious, if not more than this one, if that's possible, where jurors came back with 10-2, 8-4, things like that. So some jurors apparently, when it comes to the penalty side of it, they are very careful about this. So that's my concern. And to just say, it's harmless error, we could say that in every case, just about. So why have these rules?
And I understand your concern, Your Honor. It's obviously a question that this court has wrestled with numerous times in various cases, as you've mentioned. But if we're going to take a look at the various comments, and I'm taking it that you're talking about different comments because you mentioned the exercise of the constitutional rights as opposed to the same mercy. As long as the determination, the standard of review that the court is using is fundamental error, that's what we have, the analysis that we have to use. And in those cases where we have such highly aggravated facts, there's going to be that chance that, yes, I mean, in any case, prosecutor can make statements that may not be appropriate if, in fact, that's the statement that's not. However, this court has indicated in the past that in cases where there's substantially egregious comments made by the assistant state attorney during the case, and I don't think that this is one of those cases, it's actually stated that it would indicate that the bar may even have, should be contacted and looked into that. But what the court should not do is reverse the case, or excuse me, reverse the sentence and remand it simply to send a message to prosecutors unless there is a fundamental error in the case. And that's not the case here.
So can we get your position, though? So, I mean, obviously part of what we have to do is sort of list out what the arguable, we have to decide what were the errors and then decide whether once you've added all those up, whatever that number may be, kind of, was it so bad that essentially the defendant didn't have due process, which I think is what the fundamental error test sort of boils down to. So what's your position on, again, without getting into sort of the consequences, but as far as whether it was error at all? I mean, it seems like on the table we have the same mercy issue, the immigration issue, and golden rule. So which of those three should we even consider to have been errors?
Frankly, I question whether any of those three are errors.
And so start with the mercy thing. Why, in context, I think there's a shared understanding that even the other side acknowledged that if you limit it to the pitilessness of the crime, that it's okay to talk about mercy, but it's not okay to say don't extend mercy to the defendant because he didn't extend mercy to the victim.
Yeah, again, and I think you've just touched on that, is the fact that the prosecutor was making an argument about HAC at the time, and the fact that this defendant showed no mercy to the victim when he strangled her to death. And that's how it came up.
Okay,
now,
but he prefaced it by saying something like, when you start thinking about mercy, consider the mercilessness of the crime, right?
And then I believe he went on just to start saying, and an HAC, and that's when the objection actually occurred.
All right, how about the immigration thing? It seems like the immigration thing was at best kind of a non sequitur, right? I mean, can you give us an argument as to how it was, putting aside whether it was some, horrific thing to have said, that's kind of a separate question, but even in terms of understanding what this had to do with anything, could you just kind of give us an argument for why it's affirmatively okay for him to have said what he said?
Sure, but let me preface my response by pointing out that there was no objection, and that's why we're on a fundamental error analysis on that particular point. However, the defendant had brought up as a mitigating circumstance in this case the fact that he was born in a poverty-stricken neighborhood in Jamaica, in Kingston. There was horrible crime, it was a crime-infested area, and that he himself was subjected by his father to punishment that was severe. The state was trying to point out, the state's allowed to argue the weight that should be given any particular mitigating circumstance. I believe that's what the state was trying to do in this situation, was point out, this is something, that happened approximately a decade ago, and he's been able to change his life. He's put that behind him, and that's something this court has recognized before in indicating whether or not that's an appropriate argument. And in this case, we have someone who's moved to the United States. In his interview with the detectives, he discussed how he was working as a cell tower operator. He was making what he considered to be very good money. In fact, he made a remark, I believe, said he couldn't believe how much they paid him to do this. And I think that's the point the prosecutor is trying to make at this point, is, that happened 10 years ago, when he was in Jamaica. He's now in the United States. Things are very different here. And he's had the advantage, for instance, of having competent counsel appointed. There shouldn't be anything wrong with an assistant state attorney pointing out, or anyone stating in closing, what's great about this country. The counsel makes it out as if he's preying on the fact that he is an immigrant from a foreign country to the United States. I don't think that was the assistant state attorney's argument at all.
Well, I guess I understand how one part of the argument is that was then, this is now. But what do his, trial rights and his, the benefits of being in the United States have to do with his personal evolution? Because I think if you're going to defend this comment as not erroneous, I need to understand how all this is responsive to the argument. And it doesn't seem like all of it is. It seems like maybe some of it is. You want to say, okay, in your past things were tough, but now you're gainfully employed. Now, you've been able to metabolize the harm you suffered as a young person. Okay, I got you on that. But what's that got to do with being an immigrant? Why does he have to reference Jamaica,
Well, he referenced Jamaica because that's what the mitigating circumstances, or the evidence that was introduced for mitigation, discussed. There was a whole video introduced in this case of statements taken by people currently living in Jamaica who knew Mr. Ritchie at the time. And so clearly, if we're going to talk about his past and whether he has moved on from his past, well, what is his past? His past is Jamaica. It's not as if the state introduced Jamaica into evidence in this case. The defendant did. The
Golden rule, I think.
Thank you. The golden rule violation. The assistant state attorney clearly came up to the line, I would say. But the point that the assistant state attorney was trying to make, again, I believe, at that point, is talking about Give me just a second, please. Okay. He was talking about HAC at the time, and he was trying to explain to the jury they have to consider whether this was a heinous, atrocious, and cruel crime. And he was discussing what the victim went through. And when I say that the assistant state attorney walked up to the line, I'm not saying that he intentionally did that. He was trying to explain to the jury that they have to consider the fact that this girl went through what is a horrible death, that there was a period of consciousness where she knew what was going on. Not only was she being strangled to death, that she was being raped by this person as well. She was 9 years old, and trying to convey to the jury the HAC elements, or the argument on HAC. And that's why I say I think that if you take the argument in context, you can see that that was the intention of the assistant state attorney. It wasn't to try to play on necessarily the emotions of the jury, which is what the golden rule violation is. He never actually specified that the jury put themselves in the shoes of the victim, and that's, I think, where technically the golden rule violation requires that. So I don't think that it may not even be a golden rule violation, frankly, but certainly in the context in which he was arguing, it explains why the assistant state attorney was making that argument. You know, we need to bear in mind, it's not as if assistant state attorneys, when they're making their closing arguments, have, you know, a script that they're reading off of, you know, or a choreographed or anything along those lines. A lot of these remarks are off the top of their head. And what he was trying to explain the HAC, he was making the HAC argument, and he was talking about what this victim went through, and that's how we got into that situation. I think the other issue was the victim impact testimony from the mother in this case. Now, we're not arguing that that statement by the mother is a proper argument, it's a proper statement. I don't think that anyone would contest that it's not a violation of pain. It clearly is. What's important to bear in mind is that in this particular case, there was no objection to that. And so the proper analysis of that argument or that statement, whether or not it's fundamental error. And that's again where we get into taking a look at the facts of the case, both the aggravation and the mitigation. And clearly, and I'm sorry, I don't recall which justice mentioned it, but this is just the type of case where we would anticipate a reasonable jury is going to come back with a recommendation of death given the severity of the aggravating circumstances. We're not just talking about, you know, strangulation, manual strangulation of a person, and I clearly don't want to make it, when I say just, make it sound as if, you know, that's not a serious matter. Obviously it is, regardless of who it is. It's a painful and torturous death. That's what the testimony of the medical examiner was about. We're talking about a 9-year-old child on top of that. The jury had already, in their initial conviction of the defendant, made a determination that he raped this child. There was a capital sexual battery conviction. And the court needs to weigh that against what little mitigation there is in this case. And the court has said in the past, I believe it's in Alston v. State, that one of the things this court focuses on is the order, the sentencing order of the judge, and where we have the judge saying that she gives great weight to the 3 aggravating circumstances. And It gets little and medium weight, moderate weight. She gives moderate weight to the mitigator that there was no significant history of prior criminal activity, moderate weight to the fact that he suffered mental and physical abuse by his father, and the defendant was often absent because of 4 different families, and little weight to the fact that he was raised in poverty-stricken and violent neighborhood in Kingston, Jamaica, little weight to the fact that he was the oldest of 18 siblings and helped raise them, little weight to the fact that he was gainfully employed, and little weight to the fact that he was kind and generous to others. So in determining whether or not there's fundamental error, we compare that mitigation with the aggravation. And the sentencing court did what I think most reasonable courts would do, or not most, what any reasonable court would do, just as this jury did what any reasonable jury would do, and that is return a verdict recommending a death sentence based on these aggravating circumstances and those mitigating circumstances.
Counsel, before you end, I'd like to go back a little bit to that golden rule violation argument. I think you said it went up to the line, but didn't cross it. So I just want to make sure I understand where you think it would cross. Because what he said was, can you imagine the dread of knowing that your life is ending and you're feeling pain all over your body? And then he describes that in fairly graphic detail. And then he said, and that pain would have been greater for a little girl. So I'm trying to figure out how that's not a golden rule violation. Because, I mean, I know you said, they have to say, put yourself in the shoes. I don't see how he could have said that any clearer.
And I recognize that it's at the very best a close call. But again, there's no objection. And the question is whether or not there was a fundamental error in the case. And given the facts of this case, including the fact that the jury had already found 2 of the aggravating factors existed in their initial conviction, therefore finding the defendant was eligible for a death penalty prior to the penalty phase itself, that's not a fundamental error. And that's really the bottom line. And that's truly the bottom line of this entire case. If you take a look at the cases, was there fundamental error in this case? And when you take a look, and I feel like I'm kicking a dead horse here, but
let me just ask one more question. That's about all we have time for. But so back to the same mercy problem, the Merck versus State of Florida problem. The only contemporaneous objection was in response to this. The prosecutor says, I want you to think about this again when you're back there deliberating, when you're considering whether you should give him life and whether you should personally extend mercy to this defendant. Did he extend mercy to this little girl? Now, would you concede that that is an improper prosecutorial argument?
I think if we take it in the context of in which the argument was being made, which is whether or not...
Doesn't that do exactly what the case law says you can't do? I mean, the context is when you're personally deliberating and when you're personally deciding whether to recommend life or death, think about this, did he extend mercy to her? That's the context of that statement.
Right, but you say that's the context of the statement, but that's not the entire statement before the objection. There's not much more. But what he then says is because in heinous, atrocious, and cruel instruction, and that's when the objection comes. And that's why I keep hearkening back to the fact that the assistant state attorney in this case was making a heinous, atrocious, and cruel argument. And that's where the language slipped in.
Counsel, you're over time. If you could sum it up in about 30 seconds.
I will. Thank you very much, Mr. Chief Justice. For the foregoing reasons, we request that this court affirm the sentence of death that was imposed by the trial court. Thank you very much.
Thank you. Rebuttal.
Counsel, could you articulate for us, I want to make sure that that we understand your position on the fundamental error
Yes.
kind of test, because it seems, I'm trying to the extent that it ultimately goes to due process, it seems
Yes.
like the due process right that's at stake here is the right to have the jury make a decision on their recommendation based on reason and their assessment of these arguments, some of which are factual and some of which are kind of moral slash, subjective sort of judgment type arguments.
Yes.
And we have all these kind of guardrails in our case law that seem to be all directed to the end of keeping this a rational process. So that's why you don't do the golden rule. That's why you don't do the mercy thing. It's not because there's something sort of inherently flagrantly problematic about an argument like that. It's that it can encourage the jury to maybe cross the line into not having this be a rational sort of decision that they're making and having be more based on sort of passion or emotion. And so is it appropriate for us to read this entire argument and kind of ask ourselves, keeping in mind the guardrails that we've put up and whether the prosecutor stepped over the line in, all of these cases or some of them, but do we ultimately need to read the entire closing argument and ask ourselves, were these things in their cumulative effect sort of so far over the line that we don't have confidence that this jury made a rational, kind of reason-based as opposed to passion-based decision in this case? Because it seems like if that's the test, I would have a hard time saying that there was fundamental error. If it's more a matter of just sort of mechanically kind of adding up, how many mistakes did the prosecutor make, then maybe you have a stronger case. Could you kind of address that?
Sure. If the court is applying fundamental error, which we're arguing that you should not, but if you are, I think there is a undeniable connection between excess emotion, right? Because you cannot completely divorce these proceedings. I would not wish being a capital juror on my worst enemy. It seems wrenching. You cannot completely divorce these proceedings from empathy, rage, and so prosecutors have to ask themselves, am I going to cap it at that? Am I going to try to keep it under control? Or am I going to essentially pour gasoline on something that is already on fire? And when they choose to pour gasoline, what they are doing is they are impairing the integrity of our state's capital sentencing system, a system that this court should ensure by all its might is as sound as possible. And I think there's a connection between the excess and fundamental error. Right? Because when you err fundamentally, what you do is you err so extensively that you impair the jury's ability to, as calmly, as dispassionately as possible, arrive at a fair verdict. And these arguments are banned because they work, because they cause jurors in the capital context to impose a higher sentence than they otherwise would, because they whip people up. That's why you're not supposed to say them. So the question, I think, if you're applying fundamental error analysis, is how much do we tolerate? And this is beyond.
Well, but I think that's why, though, if you read the whole argument in context, obviously I think it sounds like from the state's own argument, it sounds like in hindsight there are some comments that the state would acknowledge maybe shouldn't have been made. But if I read the entire argument, I do see a lot of sort of reasoned application of the HAC, the other aggravators, putting all of it in context, responding to the mitigation, which is, obviously a difficult thing because it's not just a sort of who's proving a fact. It's trying to make inherently kind of moral arguments to the jury about, what weight do you give the bad, versus the good. And when I read the whole thing in context, it doesn't read as an argument that was trying to, to where someone, the hearer would have been so overwhelmed by emotion that they couldn't kind of rationally apply the standards, which at the end of the day, that's what this whole process is about, right? Is giving each side a fair chance to kind of make their arguments about the legal standards that apply, the facts, and have the jury kind of make this moral decision about what their recommendation is going to be. And it seems like in context, there was an opportunity for them to deliberate that way. Do you disagree with that?
I absolutely do. This idea of any reasonable juror would vote for death in this case is misguided.
Well, and that's
Is
just to
it-
be clear, that's not what I'm saying. What I'm saying is I'm not saying what their answer was. I'm saying the environment, were they able, after this argument, to make a reasoned sort of assessment of the case that had been put in front of them? Because that's ultimately the test, right? I mean, it's to protect against the jury basing their decision on passion. I mean, isn't that all these rules that we have, they're all directed toward preserving that interest of
Yes,
the
and I think
defendant.
same mercy, an attack on the idea of unconditional mercy inflames your passions. I think an attack on your jury trial rights, the very proceeding that the jurors are sitting to, inflames your passions. I think, especially after the last election, these anti-immigrant sentence inflames your passion. And I think the golden rules violations also inflame passion. That's the whole point of a golden rule violation, is to inflame your passion. So I think if we're in fundamental error world, again, which we should not be, but if we are, I think all of those things do exactly what you frankly seem to disagree with me about. I think that they're designed first. That's the key here. I heard my opponent say that some of these things were just off the top of his head. There is no way that is true. Mr. Harmon is a veteran prosecutor, has been prosecuting homicides for 20 years. He wrote out this argument. He gave it to colleagues, I guarantee you, and tested it. This was deliberate. And another thing that his wisdom gives him from doing this for so long is that even if I've got aggravators on lock, I can still lose. Especially in a case like this that is not, like my opponent said, one of the least mitigated. You have two of the most, and it doesn't matter what the trial judge's order said, it matters what the jury thought about the mitigation. You have two of the most compelling categories of mitigation that exist: traumatic childhood physical abuse and mental mitigation.
I'm sorry, could I ask you about this preservation issue with
Yes.
the mercy thing? Because one of the consequences of not getting a more clear ruling from the court is that there was no opportunity to sort of discuss whether there could be some kind of curative instruction on the spot. Because, I mean, on your theory, am I right to understand you as saying that as soon as that sentence or the two sentences left the prosecutor's mouth, that
The error
essentially
was complete.
that there had to be basically we have to start the whole penalty, what should the judge have done?
The mistrial should have been granted.
And which means you would do what?
That the
For the-
penalty, I assume that
so
the
we-
penalty phase would start over.
Right, we just start, so because there was no curative instruction that could have been given, the court couldn't have said, listen, I know this came up in the context of it may have been an improper mercy thing, it may have been a proper HAC thing. I want you, the jury, to understand this is what you can consider it for, but you cannot consider it for something else. You're saying that would not have been acceptable. That couldn't have fixed the problem.
There's a couple schools of thought on curatives and whether they help at all or whether they hurt. But I think what's important to remember in this case is the trial judge clearly didn't think an error occurred. So at that point, and as a former trial attorney, I've been in front of some judges where if they make their opinion clear and I ask for a curative, I'm going to get looked at like I've got three heads.
Well, but the problem is here, it seems like to the extent that the court thought there wasn't an error, it wasn't because the court disagreed about whether it would have been okay
That's
to
right.
make the argument. It was whether, in fact, the lawyer had actually said,
That's
in
true.
terms of how you heard it. So there was a common understanding that this type of argument was off base. And so if defense counsel had said, well, can we just make sure the jury understands X, Y, and Z, it seems like the judge would have been receptive to that because the judge agreed that the comment would have been inappropriate for that purpose rather than for the HAC purpose. And none of that was able to happen because of, and I'm not saying this to fault the defense lawyer,
Sure.
but because of the ambiguity about the ruling and the failure to kind of follow up, there wasn't an opportunity for that to happen.
That's correct, but I mean, it's our position that this closing argument went on to be, maybe if you take it out of that single sidebar context, went on to be so devastatingly bad that it's reversible anyway.
And let me follow up with that. So
Yes.
if you read, again, at the same point, the same mercy argument,
Okay.
the objection,
Right.
you're correct. It really wasn't a general objection. If it had been, then the judge, I think, the judge would have said, sustained, you know what you can't do, don't do that again, and we would have moved on, right? So, and essentially that's what the judge did. The judge said, well, I don't think he said that, but we know he can't say that, so don't do that again.
Right.
So if we view it as a general objection, then it was handled properly with an instruction. This is not the kind of argument you can make. So
Do you mean,
And
by
then-
general, what do you mean?
just objection, this is an improper argument. Then the judge would say, sustained, you're right, it was improper, don't do that again. That would have been it. But it was a motion for mistrial. And it's a tough road to think that simple context comment in the context of the HAC argument would vitiate the fairness of the entire proceeding. So when you look at the mistrial standard, I don't even think you argue that the judge, you don't make that separate argument, right? That the judge should have granted the mistrial.
Well, I think the mistrial in this particular sidebar exchange is sort of a red herring because the judge
But that's
is
the
clearly-
objection that was actually made. It was
I
a motion for
understand,
mistrial.
But no, I'm talking about the failure to obtain a ruling for that. I think is a red herring because once the judge makes a clear ruling on an objection, once you lose an objection, you don't have an obligation to make or obtain a ruling on a motion for mistrial.
Okay.
Counsel, you're now in overtime, but I'll give you another minute to sum up.
The state has simply not met its burden to prove beyond a reasonable doubt that a single juror was not swayed by any of these putrid arguments. The vast amount of improprieties in this case have been described in many cases by many courts in a lot of ways. There is but one word that adequately describes them in this case: reversal. Thank you.
Thank you. We thank you both for your arguments in this case. That is the final case on today's docket, so the court will now stand adjourned.
All rise.